Hello, future travelers. Welcome back to Legalopolis. Earlier this week, USCIS issued new guidance following President Trump's September 19, 2025 presidential proclamation, which introduced significant changes for employers sponsoring H-1B workers. The announcement of a new $100,000 H-1B visa fee has caused widespread confusion among both employers and visa holders. Now, with USCIS releasing detailed clarification, we finally have a clearer understanding of what this new rule really means, both for employers and H-1B professionals. And so, in this video, let's break down who must pay this fee, who is exempt from paying the fee, and how to actually pay it. Now let's see which H-1B filings are subject to $100,000 fee. Under the presidential proclamation, the $100,000 fee applies to number 1, any new H-1B petition filed after 12:01 a.m. Eastern Time on September 21, 2025 must include the $100,000 fee. This applies to the 2026 H-1B lottery and all other H-1B petitions submitted after that time. Petitions that request consular processing, that is visa issuance at a US consulate, port of entry notification, or pre-flight inspection for individuals irrespective of whether they are in the United States or not. But let's understand what is a consular notification petition and why this fee is applicable. Friends, whenever an employer files Form I-129 to classify a foreign national as an H-1B non-immigrant, they must indicate what action they want USCIS to take after approval. If the employer selects consular notification, it means that USCIS will simply inform a US consulate abroad, that is outside of the United States, about the approval, allowing the foreign worker to use that approval notice to apply for an H-1B visa at the consulate. The worker must leave the country, appear for a visa interview, and then re-enter the United States on the new H-1B visa. Now, since this process requires a physical entry into the United States to activate their H-1B status, it falls under the presidential proclamation restricting H-1B entry and is therefore subject to the related fee and security procedures. The third scenario is that the fee also applies where the petition requests a change of status, amendment, or extension of stay, but USCIS determines that the individual is ineligible. The ineligibility could be on grounds like, for example, if their status is expired, or say they left the United States before their petition was adjudicated upon by USCIS and approved, resulting in the need for visa issuance abroad, as the worker would then need to leave the US and re-enter to continue working in H-1B status. So friends, in simple terms, if an H-1B worker must leave the United States and re-enter to activate or continue their H-1B status, then the $100,000 fee applies. Even cap-exempt employers such as universities, non-profit research organizations, and government research institutions are not automatically exempt. They must pay the fee unless they qualify for a national interest exception. Now, let's look at which H-1B filings are not subject to the $100,000 fee. Now friends, there are several cases where the employers are not required to pay the $100,000 fee. This fee does not apply when, number 1, to individuals who already hold a previously issued H-1B visa, and it does not affect their ability to travel in and outside of the United States. Second, the $100,000 fee does not apply to petitions filed before 12:01 a.m. Eastern Time on September 21, 2025. Number 3, H-1B renewals will not be impacted by the fee. Number 4, a petition that is filed for extension of stay, and if it is approved, the $100,000 fee doesn't apply. Fifth, if the petition requests a change of status, for example from F1 to H-1B or L1 to H-1B and so on, and if that petition is approved, then the fee doesn't apply. Now, as regards the F1 students who want to switch to H-1B status, they must have a US employer sponsor and file the petition on their behalf. Employers hiring foreign students currently in the United States on F1 visas are exempt from the $100,000 fee. US law allows a change of status for non-immigrants, enabling the F1 visa holders, including those on OPT, to transition to H-1B. But please do remember, the student or foreign worker who has applied for a change of status should not leave the United States before USCIS adjudicates their change of status or renewal petition. Number 6. If the petition amends the employee's stay and is approved by USCIS, then the $100,000 fee doesn't apply. Number 7. If the petition requests a change of employer with an approved extension of stay, then the fee doesn't apply. However, if the employer files the change of employer petition for consular notification, meaning the employee must go to a US consulate abroad to get a visa before re-entering the United States, in that scenario, the $100,000 fee will apply. So simply put, if the H-1B employee remains inside the United States and USCIS approves the change, extension, or amendment, in those situations, no $100,000 fee is required to be paid. However, if USCIS denies the change or extension and instead approves the petition for consular processing, then the employer will need to pay the fee unless a national interest exception is granted. And so, friends, let's have a look at what are the national interest exceptions. Now, friends, as per the guidelines issued by USCIS, employers can apply for a national interest exception, but they have also made it pretty clear that these will be approved only in extraordinarily rare situations. And in order to qualify for a national interest exception, an employer must prove, number 1, this employee's presence in the United States serves the national interest of United States. Second, no American worker is available for that role. Third, they have to prove that the employee does not pose a security or welfare risk to the United States. And number 4, paying the $100,000 fee would significantly undermine US national interests. So these are the 4 things that have to be proved before an employer can be granted a national interest exception. Currently, USCIS only allows individual-based exceptions, not for entire companies or industries. And this process must be completed before filing the H-1B petition. Then comes how to pay the $100,000 fee. According to USCIS, the $100,000 fee must be paid before filing the petition. The employer should make the payment through the Treasury Department's Pay.gov portal, and the employer should include proof of payment or proof of an approved national interest exception when submitting the H-1B petition. If USCIS on a later stage issues a RFE, that is request for evidence, or NOID, that is notice of intent to deny, asking for fee proof, the employer must make sure that they provide this proof before the due date of that notice. And please do remember, the H-1B beneficiary cannot pay this fee themselves. Under the H-1B rules, employers are solely responsible for this payment as it's considered a business expense. And so, friends, to conclude, this $100,000 H-1B fee marks one of the most significant policy shifts in recent years. In simple terms, the $100,000 H-1B fee does not affect current H-1B visa holders or anyone whose petition has already been filed before 21st September 2025 or if the petition is already approved. Government agencies including USCIS and CBP have made it clear that the fee only applies to new petitions filed after the proclamation's effective date, that is 21st September 2025. This means if you already have a valid H-1B visa or your petition was submitted before this date, you do not need to pay the fee. All employers who are sponsoring foreign professionals must now carefully review each petition, especially those involving international travel or consular processing, to determine whether this new fee will apply and make sure that they are compliant with the requirement. And for all foreign nationals, it's crucial to maintain a valid status in the United States and avoid unnecessary travel while your petitions are pending, as even a small misstep could trigger this substantial cost. So, fee. If you found this video helpful, please do consider subscribing. And I wish you all the very best in your upcoming visa processing. Until next time, safe travels!